before the Constitutional Court. In the Constitutional Court, we are challenging the entire law. Here in the High Court, we are challenging the actions of the Minister, Mao, and the Electoral Commission of discriminating against NUP, even violating the law itself, the amendment. When the amendment was made, the Political Parties and Organizations Act, the law provided that there has to be a statutory instrument which creates a new IPOD, where political parties decide whether or not to remain members of the National Consultative Forum, which National Consultative Forum, NUP is already a member of. So, what these people did, because we told the people that the whole law, the entire amendment, was meant to fight, to cripple the National Unity Platform, that is how they have been not even following the provisions of the new law. So that is why that Mao, out of vengefulness and all that, wrote to the Electoral Commission, said, exclude NUP. And we're here before the High Court. We said that is wrong, that is irregular, that is illegal. You remember, Locke was in Parliament a few weeks back, and he said that now that there is a new law, let a statutory instrument be presented to us. Which is why we say that we are against that discrimination, because all discussions, these who have been meeting, talking about how to implement the new law in the exclusion of NUP, and we say that is wrong, that is irregular.
And is on rule of law. You see, we have a new law. You know, our claims are not necessarily centered on money, but rather the law. Now we have a new law, the Amendment of Political Parties and Organizations Act. But the amendment has no statutory instrument to operationalize it. All the players are interested in is who gets what, which political party to get what. But the law is disregarded. The law does not work without considering the status quo. What is the status quo? What has been there? We are still operating in the old regime, not the new regime, because the new law is not yet operationalized. And the same minister who is supposed to issue a statutory instrument is the same minister who is misguiding the Electoral Commission, the IPOD, and the others. We need the new law to be operationalized. It's the new law which will guide on the procedure, who does what, when, with who.
I mean, as you've heard in court, the date of implementation goes ahead, and Electoral Commission gave that precedence in distributing the money. So yes, the process will go on, the challenge will go on, but I think there's quite a lot of water that's gone down the bridge. The things you need to know is that, I mean, I've just explained it, that the effective date of the act is clear. And I don't think, in the limitedness of my knowledge, I don't think that the statutory instrument should actually take precedence over the act.
So, Doctor,
criminalization, okay, carries both risks and assets. The MOU of IPOD runs an electoral cycle. So until the electoral cycle is done, there was no need to do an MOU, because the parties in IPOD felt that the validity of that MOU still subsisted until the next electoral cycle. The MOU is not going to change. Excluded because the members of IPOD signed to the MOU. They went through that process, signed the MOU, and as far as we know, in the strictest sense of our MOU, NUP is not a member of IPOD as of now. At one point in time, and until that process that will culminate into the signing of the MOU by the party, committed by the party president and the Secretary General, they are not members of it. They've received the funding before, prior to the coming of the law. But the law ties receiving of that funding to membership of IPOD.